Okay, so good morning everybody, and welcome to Clover HR's new series of webinars. Today we'll be covering the key changes that are coming up in April 2020. I do hope that you find this webinar useful and that you do join in on our future webinars that will be taking place throughout the year. So do keep your eyes peeled out for these. So just wanted to start by introducing myself. Let's move on to the next slide. Okay, there you go. So this is me, Neetu Patel. I am a HR business partner for Clover HR. Just in terms of my role briefly, on a day-to-day basis, I advise employers on all HR and employment law issues, ranging from disciplinary cases to the more complex of cases such as redundancies, restructures and TUPE matters. I also provide assistance with business startups from a HR perspective, along with ad hoc support where my skills and expertise might be required for one-off project work, such as, say, for example, chairing a grievance appeal hearing on an independent basis. I do also have a tribunal background and experience in litigating cases in the employment tribunal on both sides of the fence, so employee and employer litigation. So I do think that that's quite useful to have that background when advising employers, which is what I do now, on the challenges that they might face in tribunal if an employee does decide to issue a claim against them. So that's just a little bit about me. In terms of Clover HR as a business, we are your trusted people advisors from a HR perspective, but much more than that as well. We have specialists in recruitment, learning and development, coaching and health and safety as well. So we are able to provide valuable support in all these areas too, and can effectively be your one-stop shop. So that's just a little bit about us. Just going into what we will be covering today. So there's six topics for today. So the issuing of employment contracts and the changes to that, parental bereavement leave and pay changes, the reference period change to calculating a week's pay for holiday pay purposes, employer national insurance contributions on termination payments, the change to the early May bank holiday this year, and the annual changes to the statutory rates and national minimum wage rates as well. In terms of questions, I'm more than happy to take questions, but what I would request is that we leave these until the end of the webinar. I will be providing everybody with my contact details at the end of the presentation so that you can speak to me directly or email me, whichever you prefer, with any specific questions that you might have. Okay, so let's get started. So the first topic for today relates to the issuing of employment contracts, particularly in relation to when this must happen. So I deal still with a lot of businesses that operate the practice of either not issuing employment contracts or issuing them but months, sometimes even a year after the commencement of an employee's employment with them. And a lot of employers do fail to understand the importance of this document, which is usually accompanied by an employee handbook as well. The purpose of an employment contract is to ensure that both the employee and the employer have a clear understanding of what's expected during the term of the employment, essentially. And the document can actually serve to eliminate any disputes which may arise at a later date, say, for example, in relation to an employee maybe querying their annual leave entitlement. You know, it can be a useful document to fall back on to say, well, actually, this is what your contract says, and that's your entitlement. You know, you had it when you started your employment, that's what we've agreed to, and that's your entitlement. So it can be, like I said, a useful reference document. The handbook is not a contractual document, usually, but I have seen some that are, but usually it isn't, and it's not recommended to be, but it often accompanies the contract. So our advice is that it should always be issued together. The handbook usually sets out the company's key policies and procedures, which you can seek to rely on. Say, for example, if you've got an employee that's not following the absence reporting procedure or the incorrect procedure for booking holidays and things like that. So what is changing in April this year? So at the minute, the Section 1 of the Employment Rights Act states that a contract of employment, principal statement, otherwise known as, should be issued within 2 months of an employee commencing employment with you. However, from the 6th of April this year, this will become a day one right for employees and workers. So essentially, it's not something, you've not got the flexibility with it anymore. It's got to be issued on day one. And why is it important that, you know, employers comply with this? Well, like I've just mentioned, not only is it important from setting out the rules and entitlements from day one, if there are any disputes, which there can be quite early on into an employment relationship, but it's also important from the perspective that if you don't comply, then an employee can actually claim between 2 to 4 weeks' pay in an employment tribunal. Although please do rest assured that it's not a claim in its own right. So it's not just a claim that can be a standalone claim that can be issued in the employment tribunal. It has to essentially be tagged onto something else. So for example, a discrimination claim, or, you know, if an employee comes on board and then resigns and tries to claim something, then they might tag it onto that as well. So it's not a standalone claim, but they can, you know, if they do bring a claim and they tag that onto it, it can be an award of between 2 to 4 weeks' pay. In terms of the second bullet point there, the tribunal can award, like I said, 2 to 4 weeks' pay. The statutory cap as well there, which is referenced for you. In terms of planning ahead, what we do advise is ensure that your template documentation is all compliant and up to date. And when you're recruiting as well, just make sure that now moving forwards from April, that you've got the contract of employment at least ready to be issued to the employee on day one. So if you do have an induction process that you follow, you might want to look at reviewing that to make sure that that particular step is included as part of the tasks for day one when you're taking on a new employee. And if you do require any help reviewing your template documentation, your contract of employment or handbooks, then we can support you with that as well as a business. So do get in touch. Moving on to the next topic for today, which is parental bereavement leave and pay changes, which comes into effect on the 6th of April this year, and it's a new piece of legislation. So at the moment, there is actually no requirement for employers to grant compassionate leave or even provide pay for it if they do allow time off. However, the new legislation seeks to change this. So effectively, like I said, it comes into force on the 6th of April this year. The new piece of legislation is the Parental Bereavement Pay and Leave Act, which states that primary carers, so it's not just parents, will be entitled to time off work following the death of a child under the age of 18. This includes adopters, foster parents and guardians, as well as the more informal groups as well. So, your close relatives or even family friends who have taken responsibility for the child's care in the absence of parents. In terms of the eligibility, it's a day one right. So there's no minimum service qualification for an employee to be eligible to take that time off. They can have up to 2 weeks leave, which can be taken in one block of 2 weeks or 2 separate blocks of a week at each time. and it will be paid if the employee qualifies, which I will talk about in a second. And it also applies to parents as well who have suffered the stillbirth of a baby 24 weeks or more into a pregnancy. So that's just a point to note there as well. The leave does need to be taken within the period of 56 weeks from the date of the child's death. And so it doesn't have to be taken straight away if they don't want to. And what some parents we suspect might do, or some carers might do, is maybe take a week immediately at the time of the event, and then they might want to take another week, say for example on the first anniversary of the child's death, which is fine as long as it's taken within 56 weeks of the child's death. There's no notice requirement if the leave is taken straight away, but if they do take it a period of time after the child's death, then there are notice requirements, so you will need to take advice on that or look into that. So yeah, that's just in relation to the notice requirements there. And in terms of the pay side of things, statutory parental bereavement leave pay will be available to employees with 26 weeks continuous employment with their employer. And if they don't qualify for the pay, so they've not got the service, then they're still entitled to the time off. So they've still got the statutory right to take the time off, but it'll just be unpaid if they don't qualify from a service perspective for the statutory payment. Which will be, as of April 2020, £151.20, which is the same as the new rates for statutory paternity pay, maternity pay and things like that as well. Just as a point to note, just remember, and I'm sure you are all very aware that this is statutory right, so employees shouldn't be subject to any form of detriment or any unfair treatment if they do exercise their right to take this particular leave, as it would expose the employer to a potential claim. You know, that's something that they've got the right to exercise, and employers should be supportive if employees do want to take that particular, if they do want to take statutory parental bereavement leave. Okay, so in terms of just planning ahead, just briefly, please do make sure that in advance of the change and the legislation coming into force in April, that your family friendly policies are updated to include this change, and you know, communicate it to your staff, make staff aware of it, so that you know everyone's sort of aware of their rights, and you know that it is something that the business is supporting. Should unfortunately anybody suffer the death of a child. And if you need any support with this, again, Clover is something that Clover HR can help you with in terms of bringing your policies up to date with the new piece of legislation. Okay, so the next topic for today is holiday pay reference period. And I'd just like to make a quick sort of note on this, really. So in terms of what's changing, this is essentially what you need to know. So it's again another change that's taken place on the 6th of April this year, and applies to employees that are on contracts, variable contracts, seasonal contracts, or 0-hour contracts as well. And the holiday pay reference period is increasing, so that as of April, the last 52 weeks worked will need to be taken into consideration. Currently it's 12 weeks, so you look back 12 weeks where you've got atypical workers that are not on a fixed sort of salary every week, but that is increasing, like I said, to 52 weeks. If there are any weeks that a worker hasn't worked or received any pay, you exclude those weeks, and if there are less than 52 weeks, then you just take as many weeks as you can to get the average. And the purpose of the change is to allow greater flexibility for workers in choosing when they essentially take the holidays, in particularly for those that are in seasonal roles that are sort of quieter at certain times of the year. So that's essentially the reason for the change being made. Now, I'm not sure how many of you on here work on administering your company's payroll, It might be outsourced, you might have an accountant that does it, you might have somebody within the business that does it, but just as a practical point more than anything, just make sure that they are aware of the change, to avoid any grievances, gripes, or even in the worst case scenario any claims coming in via ACAS or the tribunal in relation to holiday pay and not being paid in the correct sum holiday pay claims. So just obviously just from an awareness perspective, just make sure the relevant people have been informed. Okay, so again, moving on to the next topic, employer national insurance contributions on termination payments. And again, just a quick note on this, really, more from an awareness perspective. And you may have heard about this because it has been proposed for a couple of years now, but it is actually happening this year. So currently, neither employee or employer national insurance contributions are payable on termination payments. Otherwise, you might be more familiar with the phrase settlement payments over £30,000. However, from the 6th of April this year, employer, so not employee, national insurance contributions at a rate of 13.8% will be payable on termination payments above £30,000, which are anything over and above £30,000 are already subject to income tax, so that won't be changing, that will remain the same. The termination payments will continue to remain exempt from employee national insurance contributions. Now, these Class 1A contributions will, as I understand it, do double check on this point with your accountants, but will have to be paid monthly. So you will see these figures when you're calculating your month-end liability. And it will have to become part of the monthly payroll if it is something that you do process. So just, please ensure for any settlement of payments above £30,000, the correct tax is paid, obviously. And on a practical note, obviously, you'll need to be taken into consideration when you're actually in the negotiation phase of, negotiating a figure for a settlement sum, as the tax side of things will be, will need to be taken into consideration as an additional cost to the business. So obviously that needs to be something that employees need to be aware of. Okay, so the next topic I want to move on to is the change to the early May bank holiday this year, which you probably all are aware of. So it has been announced that the spring bank holiday this year will be moved from Monday the 4th of May to Friday the 8th of May. And it has raised some concerns, even though it has been made to coincide with the 75th anniversary of VE Day. But there are a number of implications for businesses to consider. And there also lies an opportunity, I guess, for organisations to be proactive and highlight early the impact of the change on their workforce. So why does it matter? I mean, it's a direct swap from the 4th to the 8th, so there's no extra, it's not like it's an extra bank holiday like there was when we had the Queen's Jubilee. There's no need to recalculate full-time annual leave entitlements or anything like that. But it will affect part-time workers or employees with irregular working patterns, in particular where bank holidays are treated as part of their annual leave entitlement. So, for example, part-time employees who wouldn't normally work on a Friday will benefit from an increase in the holiday entitlement, as they won't need to book any time off on that day. And on the other hand, those that normally are off on a Monday but working Fridays will see a decrease. Employees working different hours each day will also be impacted depending on whether they're doing more or less hours on the Monday or Friday. And I guess the change will benefit most those working short hours on a Friday. So just by taking a proactive approach as an employer, you can identify any potential issues early and engage with your staff to assess the impact and find, a suitable solution. And it will send the right message by doing that. You know, it'll show as an organisation, as a business, as an employer, you understand, you recognise the importance of staff having time off, you know, signal your commitment to work-life balance and help manage staffing effectively to ensure compliance ultimately. It'll bring significant benefits to employee engagement and motivation without requiring much resources in dealing with staff queries, gripes, which can often be time consuming and affect morale. So, you know, the heart of the issue will lie in the wording of the existing contracts. And what I suggest is you review your wording and you know, identify if it's going to cause you any issues, and take advice. Again, we can support you with that if you do feel like it's going to cause you issues, so we can, you know, give you the best advice in terms of how to tackle those issues, and deal with them in advance so that there's not any queries or gripes coming your way in May. So that's it on that really. And then the final topic for today really is the new rates of pay from April 2020, which increase every year. So the new statutory rates I've listed here. This is again just more of an FYI for you all. You are probably all aware. You know, whoever deals with your payroll will be aware of this because this is something that changes every year. I have put the statutory bereavement leave pay in there from April this year as well, and as you can see, it is the same rates as everything else. So these are the new rates from April, and then the national minimum wage also goes up every year, and I've listed them here. If you do want copies of this, let me know and I can ping it across to you. It's not a problem. So those are the new rates for the national minimum wage rates as well. And that's it for today. It was just intended to be a quick snapshot of the key changes for April. I would like to personally thank you all on behalf of Global HR for your attendance today, and I do hope that you found the session useful. Please do let me know if you've got any feedback or comments. Or if there's anything in particular that you would like to see in future webinars as well, let us know. You know, we'll be more than happy to accommodate where we can. I'd also like to take this opportunity to mention that as a thank you for attending today, Clover HR are offering a complimentary 1-hour review of your contracts of employment and handbook, with suggestions being made for any required amendments to bring them in line with current and forthcoming legislation. So if I've got my details here, so if you do want to take us up on that offer, please do get in touch. You can contact me via email or on the mobile if you've got any questions or queries as well. I'm happy to take questions, queries, anything really on mobile or email. If you prefer the landline, I'd suggest the 0161 number is the best one for you. So yes, if you do want to take us up on that offer, please do get in touch. It is only valid for 2 weeks, so will therefore expire on the 19th of March. So if you do want to take us up on the complimentary review, you've got until the 19th of March to get in touch effectively. And if you do email me, just please do copy in my colleague Charlotte, because I'm actually due to go off on maternity leave in a couple of weeks. So if I'm not able to pick it up for whatever reason, Charlotte will. And yeah, that's it really. So thank you once again for attending. I hope you found the session useful, and I look forward to seeing you on future webinars. Thank you everybody, and hopefully we'll see you again.